as the chair of this panel B, and this is opening our session to the Medical Board of California Panel B, July 27th, 2017. And I have to my left here our Judge Liu, who will be proceeding over these documents that we have here before us. And do we need roll? We've already had it.
Michelle Bola, or
Present.
excuse me, Dr. Bola.
Present.
Ms. Lawson.
Here.
Dr. Nanadev.
Here.
Dr. Krause.
Here.
Dr. Levine.
Here.
Hines. Here. Dr. Wells.
Here.
Jeff Quorum.
Thank you.
Great. Good morning. Thank you, Dr. Bolot. I'd like to go on the record at this time as our court reporter. Ready? Thank you. We are now on the record, and we're hearing the matter of oral argument on an accusation proceedings involving Dr. Felix Louis Negron.
That's correct.
Dr. Negron is represented by Mr. James T. Studer, is that correct?
Yes.
And representing the complainant is Deputy Attorney General Cindy M. Lopez.
Yes, good morning.
Good morning. My name is Jonathan Liu. I'm with the State Office of Administrative Hearings. We assist the Medical Board on hearings on oral argument such as this and many other agencies. For the record, this has the Board's case number 800-2016-020748. Also, the Office of Administrative Hearings case number 2016-090-691. This oral argument is pursuant to a non-adoption order dated May 8, 2017, after which a notice of hearing oral argument was issued on June 26, 2017. This particular argument is before Panel B. All panel members are present. Just to remind the parties, the way that we would like to proceed this morning is inviting first the respondent to have 15 minutes for opening. It will be followed by a 15-minute response by complainant, then a 5-minute closing, followed by 5 minutes. What I'd like to do is signal by hand 5, 4, 3, 2, 1, so counsel will have an idea how to best time themselves. As you both know, the arguments are confined to matters on the record. I don't expect that you were going to do anything else, but if there are any questions or objections, I will handle those accordingly. I am not sure whether the board members will have questions or whether that's something that we've typically done, but I will allow that at the end as well. If there are no other preliminaries or questions, we will proceed by way of oral argument. Mr. Studer, you may begin. There's a microphone. I'd appreciate it if you pull that toward you.
Okay.
And use that.
Would the board prefer if I stand or sit?
Whatever you're more comfortable with.
Good morning. If it please the board, on behalf of Respondent Dr. Negron, I'd like to address the inquiry question of whether the discipline imposed under the current order is sufficient to protect the public and whether it should be modified. I'd like to cover points that are not addressed in my brief. At the time of the accusation, Dr. Negron was a part-time family practice physician working for Simi Health Center with its owner, Dr. C.R. Joshi and Dr. Farara Hassan. He had closed his solo practice about 5 years earlier. As part of controversy about a board complaint, there was a stipulation that he would receive a letter of reprimand and attend PACE. He felt that his medical record-keeping skills needed to be improved and that he could benefit from the remedial training program. At PACE, He performed in the lowest percentile on academic tests given to medical graduates fresh out of school. He was 30 plus years out of medical school. On a Primum computer simulated exam designed to test would-be doctors' ability to treat patients in a practice setting for competencies previously examined at the bedside, he missed 6 diagnoses and afterwards said he had difficulty operating the computer software and putting his answer into the computer with the time constraints. His history and physical, he was cleared without any abnormality. He was noted as having touched Dr. Pickerel on the abdomen during a mock patient exam. He used cursive language at PACE. A computer program indicated that he plagiarized some portion of a report that he did. His pre-PACE medical chart showed need for improvement, though he did pass the medical records keeping course. On the surface, that would seem to indicate a problem on his part. In looking at the PACE brochure about what is core at the program, it notes that physician competency assessment evaluates 6 general domains of clinical competence defined by the Accreditation Council on Graduate Medical Education and the American Board of Medical Specialties that include patient care, medical knowledge, practice-based learning and improvement, interpersonal and communication skills, professionalism, and systems-based practice. A physician must be competent in each of these 6 domains in order to safely practice medicine. Now, the PACE brochure says that there are core components of the competency assessment, and the core components identified are oral clinical examination, physician health screening, and clinical observation with UCSD faculty. Dr. Negron's clinical competency assessment performed by 2 physicians who examined him orally with 4 mock patients gave him a satisfactory passing score. He didn't have the luxury of talking about the computer software simulation and difficulty in putting in his answers when orally examined in his native environment of seeing patients by 2 peers. He was able to perform and demonstrate his ability to safely practice medicine. And none of those doctors noted any indication of impairment on his part. The second part of the exam involved him shadowing 7 UCSD family practice physicians over a 4.5-day period in seeing patients at the University of San Diego healthcare system. This involved assessment of his clinical competency in domain categories of patient care, medical knowledge, practice-based learning, improvement in interpersonal and communication skills. The 6 domains felt to indicate ability to safely practice medicine. The core components found in most of the competency assessments according to PACE. None of these doctors noted any concern about any impairment on his part. In phase 2, he received very positive ratings indicating that he does have the ability to safely practice medicine. 2 doctors rated him superior in all of the 7 categories. 1 doctor rated him superior in all categories with the exception of 1 satisfactory. 2 doctors rated him superior in all categories with the exception of 2 satisfactory scores. 1 doctor rated Dr. Negron with 2 superior scores and 3 satisfactory scores. Finally, one doctor rated respondent superior in 5 categories, a satisfactory in 1, and only 1 unsatisfactory from the total 7 doctors in each of the 6 cognitive domain categories. And that was a concern about professionalism, that on the last day he seemed tired and wanted to take a break and wanted to leave early around 4 p.m. to beat the traffic going back to Ventura County. There was a neuropsychological examination done by an assistant of Dr. Perry, a psychologist at PACE, and it was interpreted as him showing normal functioning in various categories, but concerns of minor impairment in the categories of executive functioning and ability to memorize words. There was a recommendation that he should get a complete workup, a repeat neuropsychological examination, and a complete neurological examination, which he did. He was evaluated by Dr. Kim Barris, a clinical psychologist who has quite impressive training, who has evaluated Dr. Negron over a period of time, performing neurocognitive testing while during stimulant therapy and cognitive training exercises. He found some attention deficit disorder, recommended treatment with Vyvanse and daily cognitive training exercises to see the nature of his condition, to see if it would improve, stay the same, or worsen. What I think this case boils down to is on the core components of the competency assessment at PACE, Dr. Negron appears to have demonstrated the ability to safely practice medicine when evaluated by 9 peers on oral competency assessment and clinical observational, where they were able to see him interacting with patients, taking histories, making assessments, sharing his knowledge of differentials in each of the various disease categories, and he seemed to perform well in that context. In the context of taking the medical school examination that's given to medical school graduates, he seemed to score low. I asked Dr. Norcross on cross-examination, well, what would you expect for a doctor 30 plus years out of school? Would you expect his test scores to be the same as a medical student who's fresh out of school with it fresh in his mind, his mind, her mind? And he said, I see where you're going. He says, ideally they should be the same. But he said, I note your point. I don't know if the practice, it would seem an analogy. I've been practicing law for 28 years, and to take the bar exam cold without studying it, I'm sure I would do well in categories where I've used the knowledge, and probably poorly in areas where I haven't had the occasion to use. But, you know, there was an early adjudication by Judge Dash, who felt that that looking at the core testing, that Dr. Negron demonstrated his ability to safely practice, and that there was a valid concern about the neuropsychological testing and what impact that might have on his ability to safely practice medicine. And he requested an independent medical examination and told us to find somebody at UCLA in the gerontology department, preferably with some background in neuropsychology. And we found Dr. Hugh, a clinical professor of gerontology with a background in neuropsychology. He looked at everything, and and reported that Dr. Negron did have some level of impairment, that he performed poorly on certain tests that were given at PACE, but there appeared to be strong evidence of his ability to perform clinically in family practice medicine. And he shared the current knowledge of the trajectory of mild cognitive impairment, that it can stay the same, it can improve, reverse completely, or progress to dementia. And what he recommended was that Dr. Negron continue to take the Vyvanse, continue the training exercises with Dr. Barris, and that he be allowed to go back to work under the close supervision of Dr. Joshi. Dr. Joshi and Dr. Negron have worked together closely since the 1970s. Dr. Joshi shared that Dr. Negron is an asset to the clinic. Not only is he a highly experienced family practitioner, but he's also bilingual. And a doctor of his background is an asset to the public. And Dr. Joshi felt that if there was any impairment in his ability to safely practice, he would note it. The mechanism that was proposed, that he be allowed to go back to practice under the supervision of Dr. Joshi, no solo practice, that he continue to take Vyvanse and continue to have neurocognitive assessments, would appear to be reasonable and appropriate under the circumstances, and it appears that there's been great effort to protect the public here. Not only was there a comprehensive assessment by PACE, 9 doctors evaluating him orally and observing him clinically that found him safe in his clinical environment, but there was a neuropsychological test that put the spotlight on an issue. A highly experienced clinical psychologist has been working with him for the past year and a half. He was evaluated by Dr. Arthur Cal, a professor of neurology from UCLA, who looked at everything, said he didn't see any medical or mental condition that would impair his ability to safely practice medicine. And he gave Dr. Negron the clearance that PACE wanted. It would seem that in the totality of things, that what is core, according to the PACE manual, is his performance on the oral clinical examination and the observational performance on number 2, phase 2, and medical clearance. And on that basis, we submit. Thank you for letting us present a case.
Mr. Studer, thank you very much. And now, Ms. Lopez, you may begin.
Good morning. I'm going to start at the very beginning. When this case first came to us, it came to us pursuant to vertical enforcement, where both myself and an investigator were assigned the case, and it went very smoothly as a result of that. In November 2014, we reached a settlement where a public reprimand would be issued and certain conditions would be performed, one of which was successfully completing PACE. So not just going to PACE, but obviously successfully completing. Unfortunately, when Dr. Negron went to PACE, he did not pass phases 1 and 2. Just briefly, there was a mock patient history. He was deemed not to be within the standard of care. There was something called a MICROG computer assessment. He performed in low ranges for things like cognitive functioning, reasoning, information processing speed. Obviously, all of these are characteristics of a competent physician, or they need to be performed competently. He did something called a primum, which is another computer-based test, and he scored in the lowest. On a 100-item multiple choice test, again, scoring in the lowest. So in phase 1, he did not pass. And then he was evaluated psychologically, and they found that his performance was impaired. His executive functioning, which refers to cognitive abilities to plan, to think abstractly, to initiate appropriate actions. Again, all of these are characteristics of a competent physician. He performed in the low range. Dr. Perry found that he was very concerned about deficits on cognitive testing, and he found that these were not sufficient enough for the independent practice of medicine. Phase 2, same thing. There were several parts of Phase 2 where the doctors at Pace did not feel that he passed. So, based on Phase 1 and Phase 2 and the finding of mild neurocognitive functioning, they gave him the lowest passing grade, or excuse me, a low failing grade. We filed an accusation, and then it went to hearing. So, at the hearing, both Dr. Norcross testified, who I'm sure the board is aware is the founder of PACE. Dr. Perry testified, and after a day and a half or two of the hearing, the ALJ, who was there obviously to determine the credibility of the witnesses, to see their demeanor, she found that we proved the case by clear and convincing evidence. And again, she found that there were several parts of these phases that he performed unsatisfactorily. Now, the ALJ put him on probation and gave him 5 years with a couple, and I want to emphasize just a few conditions. She required him to do a neuropsychological evaluation every 6 months, and then prohibited solo practice. That was all. Now, as this panel is aware, public protection is the highest priority. That's what you're here for. That's what my job is to make sure that Dr. Negron is safe to practice medicine. Now, this is not a revocation case, so we are not arguing that he should be revoked. But what we are suggesting is that there be a few more conditions. And again, this is so that the public, whether it's you or anyone in this room who goes and sees Dr. Negron, that they can be assured that the person that they're seeing is 100% competent to practice medicine in front of them. So what we suggested are just a few more conditions to be added. Number 1, a practice monitor. And I do not know or understand why the ALJ did not include this. This is a perfect case for a practice monitor. Now, it cannot be someone that Dr. Negron works with. It needs to be someone who is very objective. And we're recommending that that be in the first 2 years of probation. After the first 2 years, if that probation monitor feels that Dr. Negron is safe to practice without a probation monitor, then that condition can be deleted. Secondly, and really almost equally, if not more important, is regarding the neuropsych evaluations. We agree that they should be every 6 months, but we'd like to add that if, as a result of these evaluations, that this evaluator finds that Dr. Negron is unable to practice independently and safely, that he will need to stop practicing. And again, I know I keep emphasizing this is a public protection issue. Anytime we discipline a doctor, that's the only thing that we should be thinking about, and of course, secondarily, rehabilitation. So if this, after this neuropsych eval, if that doctor feels that Dr. Negron, for whatever reason, should not be practicing, then a cease order needs to issue. So the 5 years probation is fine, the neuropsych is fine, but just, and this is on page 5 of my brief, we would just like to add those 2 conditions. Thank you very much.
Thank you, Ms. Lopez. Mr. Studer?
You know, the quandary here is that Dr. Negron demonstrated his ability to safely practice when drilled in an environment that he was familiar with to practice in medicine. I've never been part of a physician competency assessment, but I would assume that it's not easy. when two physicians examine and drill a physician with mock patients. I would assume that there are efforts to try to trick, that there are efforts to evaluate how the doctor thinks and processes the information. Does he appear to be slow? Does he appear to be hesitant or unable to execute or think out of the box? And in this case, two doctors did an oral examination and passed it. And 7 doctors evaluated him over a 4.5-day period, and they had extraordinary comments about his knowledge of differentials and his application and his insights into the care situations. And it gives a picture of a mind that is functioning in a way that is safe for the public. And there is a concern raised about his scores on neurocognitive testing being below average, and that raises a concern, but there's been no effort, and admittedly, there's no research that correlates a weakness in any of these two cognitive domain categories and ability to safely practice medicine. Now, it's very seductive to go with the idea that, well, if there's some impairment and there's a possibility of him progressing to dementia, well, that could endanger the public, and that might be something difficult to monitor, and that might require something in addition to what's already in place. First and foremost, he has a responsibility to the public to monitor himself. And the record is that he's worked with a neuropsychologist 3 to 4 days a week for 1.5 years, dealing with this issue, cognitive training exercises, the use of medications, that he runs a 5-mile mountain state to keep himself in shape. And the exercise is extraordinary executive functioning in terms of what's expected of him as a physician to keep himself physically fit as well as cognitively fit. And Dr. Joshi, it would seem that Dr. Joshi would have more to lose than to gain by what he told the ALJ about his intimate knowledge of Dr. Negron's practice of medicine. The two of them work together. They see the same patients. They work as a team. They work under the same roof. It's a small urgent care center, and that he monitors, and an employer that has hired him under the circumstances would seem to be inviting a lot if what he's said or what he says about this physician's abilities isn't true. And it would seem that he can carefully monitor, and that the requirement of an additional practice monitor would not be necessary under the circumstances. It seems that there's been extraordinary protection, beginning with Dr. Negron's insight that my medical records could be improved, stipulating to the letter of reprimand, taking on the PACE challenge, going there, demonstrating his abilities to tertiary physicians at the university environment. And other than that, I don't think we're really that far apart in terms of what's necessary to protect the public. Respectfully, we don't think a practice monitor is warranted under the circumstances. Thank you.
Thank you. Ms. Lopez, last word.
Actually, I think I'm going to do something different than I've ever done before. Normally, when we do these non-adoption briefs, and I'm talking about the Deputy Attorney General, we're really not told what concerns the panel. I mean, we can kind of guess and speculate based on when we get the little notice of hearing, but to be honest, we can rarely read your minds. So I guess my question back to the panel is what the panel is concerned with. And again, and I'm going to sound like a broken record. Obviously, public protection is what we're most concerned with. So if there's something in this proposed decision that the panel thinks we need more of, and I already argued in my brief and just in my argument, I'd like to add those two conditions. But if there's something else, if there's questions that you have of me, since I'm the one that did the hearing, and I've actually been dealing with Dr. Negron for several years, and I can say that he is very sincere in his wanting to get better, wanting to rehabilitate. I don't say that very often when I come before this panel, but I can definitely say that of Dr. Negron. But if there's questions that the panel has of me, I'd be more than happy to answer them.
Right. We'll do that. We'll consider this as your argument, and now we'll proceed to the questions. I'll look to my far right first, and then we'll move this way. Do you have any questions?
Questions right away.
Judge, I have a question for Dr. Negron, so if you can swear him in that round.
Well, we can't take in new evidence.
No, we're not.
I'd like you to pose the question to counsel. And if the parties stipulate that they wish testimony of Dr. Negron, I will do that.
Let me ask. Yeah, it's fairly simple. What's your plan, Dr. Negron? Sorry. MCI is poorly misunderstood by the medical community as well as the public, and certainly the legal community. So my first thing was get your little button gear, do the best you can in terms of dealing with this problem. And I've tried. I continually get up very early every morning. I run up and down a hill. I do my practice exercises, and then I go into the clinic and I do my reading. I see it as a challenge. I don't see it as something that's bad. The good thing that's come out of this is that it's focused me in a different direction. That's number one. Number two, I think for a happy, successful life, you got to have purpose and direction. I don't care what direction it goes in, but you just got to have that. So I've tried to make that a focus of my life. Dealing with people, since I've done with them for 40 years, as you well know, family practice doesn't necessarily remunerate that well, but you're not really doing it for the money. I enjoy the patients, still do. I still see them every day in my daily activities, talk to them, still share their problems to the extent I can. So I take care of myself, try to get myself to where I can practice again, get my license again, and try to go back to do that with the patients. Eventually I'm going to have to leave it. I understand that. But the good thing from my own personal point of view is I've had something shake me up, which most people don't have, and I've tried to focus and deal with it. The secondary thing is to help the patients. So all I have to do is, the other thing that gets me is, as you age, and it's going to happen to all of you, there's a poem. I just remember the last two lines of that thing. It says, I am the captain of my ship. I am the master of my fate. So before that opportunity slips away, I'm going to give it hell. I'm just going to give it hell. That's why I'm here before you. That's why I poured as hard as I have. And win or lose, I still enjoy the fight.
I'm going to do two things. You had no objection to that coming into the record? All right. And Dr. Negron, I'm going to swear you in. Do you swear or affirm that your testimony before this board is the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
And certainly you also agree that your past statement is something that you would testify to right now.
Absolutely.
Thank you very much. Continue.
No questions.
All right, counsel and Dr. Negron, thank you very much. This matter is submitted. The board is going to meet in closed session, and the decision will probably issue within at least a month, if not well before. Thank you. Off the record.
Thank you, ladies and gentlemen.
Let's go on the record, please. And good morning. We're now hearing before Panel B of the Medical Board of California a petition for early termination of probation. This has the board's case number 800-2016. 021773 and Office of Administrative Hearings number 2016-110676. My name is Jonathan Lewin with the Office of Administrative Hearings, appearing on behalf of the Department of Justice as Deputy Attorney General Cindy Lopez. By way of history, there was a hearing back in February before Judge Waxman, and he issued a decision. There was a non-adoption of this decision dated May 8, 2017. This matter was then noticed for hearing on June 26, 2017. This matter was noticed for 9:45 a.m. I'd like to indicate at this time that there's no appearance by or on behalf of the petitioner. Of course, Ms. Lopez is here, and I'm going to, Ms. Lopez, if you can kindly communicate on the record what we've learned about the non-appearance of petitioner.
Sure. Good morning, Cindy Lopez, Deputy Attorney General. From my understanding, I received an email, I think last week or maybe early this week, that from petitioner's daughter/attorney that they were not going to be appearing. So they filed a brief, but they're not going to be appearing to do the oral argument.
Okay. Now, of course, you're not technically with the burden. You represent the Department of Justice. Do you wish to state anything beyond what you've already done in your pleadings?
I don't think so. I mean, it's pretty straightforward. I can just give a really very brief history. I've had this case also for several years. Again, it started with vertical enforcement. This is my oh so subtle way of telling you the importance of vertical enforcement. I'll leave it at that. There was an ISO that was issued. This was a very serious case. There was allegations of sexual misconduct with one patient, and at the time, Dr. Tincopa was a pretty elderly man at that point, and we filed an ISO because we felt that he was so unsafe, and then we ended up settling the case for 5 years probation, and there was suspension time and certain conditions, one of which, the most important of which, is for him to have a chaperone. So he filed a petition for early termination, and at the hearing, English is not his first language, so I felt like it was a little bit difficult for him to really impart upon the ALJ the importance of him getting his probation terminated early. But as I said in my brief, if you look at the regulations and if you look at the statutes that talk about early termination and rehabilitation, it talks about, 1, evidence of any crimes committed subsequent to the acts in the accusation. Well, there are none. The time that has elapsed since the misconduct, it's been well over 5 years. And then the most important part is evidence of rehabilitation. So he works with his wife. His wife, I believe, is a nurse practitioner. He has followed to the letter having a chaperone anytime he sees a female patient. And he testified that when there is no chaperone at his office, he literally will not see that patient. And he will either have his wife see the patient or they send her home. And I've done so many of these sexual misconduct hearings. I feel like I'm the pro on this for some reason in my office. And I can tell you, he seemed very sincere to me. Believe me, if he wasn't, I would be saying to you, you need to revoke him. He seemed very sincere. And like I said, he always has a third party present. Again, we're not told why the panel is concerned about the proposed decision. However, I'm going to speculate that when the ALJ said that respondents satisfied most, and I'm using that in quotes, most of the board's criteria, maybe it gave the panel pause to say, well, what didn't he satisfy? If it was most, what didn't he satisfy? That was a very bad word for the ALJ to use, because I did look, again, it's in my brief, I did look at Business and Professions Code section 2307. I did look at the Code of Regulations to see what is it that this respondent was missing, and I did not see anything. So if that's what gave the panel pause, I don't think that there was anything that was missing. The respondent talked about what a privilege it is to practice medicine. Again, you don't hear that very often in these hearings. He talked about the patients that he serves. It's a very disadvantaged group of patients, and in Los Angeles, there's not a lot of doctors who want to necessarily serve that population. So I'm not, if that's what the panel is concerned with, I'm not sure there's a concern. So if there's any questions, I'd be happy to answer them.
Great, thank you. Panel members?
So I'm taking it for granted that so you're recommending for us to approve the ALJ decision. Is that what it is?
Yes, unless there's something that the panel sees that, again, I can answer any questions, unless there's something that you see that I'm missing, but yes. Questions?
All right, thank you very much, Ms. Lopez.
Thank you.
Matter submitted. Nice to see you.
Yes.